Constitution of United States. Article 3, Judicial Department has 3 sections. Section 1, Judicial Power, Courts, Judges. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office. Section 2, Judicial Power and Jurisdiction. The judicial power shall extend to all cases, in law and equity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state, or the citizens thereof, and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3, Treason. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood, or forfeiture except during the life of the person attainted. What do you think of Constitution of United States, Article 3, Judicial Department of United States? Write your comment in the comment section. 28 U.S. Code Section 1346, United States as Defendant. According to the section, the district courts shall have original jurisdiction, concurrent with the United States Court of Federal Claims, of 1. Any civil action against the United States for the recovery of any internal revenue tax alleged to have been erroneously or illegally assessed or collected, or any penalty claimed to have been collected without authority, or any sum alleged to have been excessive or in any manner wrongfully collected under the internal revenue laws. 2. Any other civil action or claim against the United States, not to exceed $10,000 in amount, based on the Constitution, any act of Congress, any regulation of an executive department, any express or implied contract with the United States, or for liquidated or unliquidated damages in cases not sounding in tort, except that the district courts shall not have jurisdiction over any civil action or claim against the United States based on any express or implied contract with the United States, shall not be subject to district court jurisdiction. B. The district courts, together with the United States District Court for the District of the Canal Zone and the District Court of the Virgin Islands, shall have exclusive jurisdiction of civil actions on claims against the United States, for money damages, accruing on and after January 1, 1945, for injury or loss of property, or personal injury or death caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of his office or employment. Under circumstances where the United States, if a private person, would be liable to the claimant in accordance with the law of the place where the act or omission occurred. No person convicted of a felony who is incarcerated while awaiting sentencing or while serving a sentence may bring a civil action against the United States or an agency, officer, or employee of the government, for mental or emotional injury suffered while in custody without a prior showing of physical injury or the commission of a sexual act. C. The jurisdiction conferred by this section includes jurisdiction of any set-off, counterclaim, or other claim or demand whatever on the part of the United States against any plaintiff commencing an action under this section. D. The district courts shall not have jurisdiction under this section of any civil action or claim for a pension. E. The district courts shall have original jurisdiction of any civil action against the United States. F. The district courts shall have exclusive original jurisdiction of civil actions to quiet title to an estate or interest in real property in which an interest is claimed by the United States. G. The district courts of the United States shall have exclusive jurisdiction over any civil action by a covered employee. If you have any questions, feel free to write in the comment box.
According to the Fair Labor Standard Act 1938, a lawsuit shall be brought against employers under the FLSA Act. However, per requirements are set in order to enforce Section 29 U.S.C. 216b. The section provides a clear direction to the parties involved in the enforcement of 216b. Any employer who violates the provisions of Section 206 or Section 207 of this title shall be liable to the employee or employees affected in the amount of their unpaid minimum wages or their unpaid overtime compensation, as the case may be, and in an additional equal amount as liquidated damages. The condition pursues to find the violation prior to the enforcement, and finding violation must be identified by the Department of Labor, who is responsible to conduct the audits in order to find violations of Section 29 U.S.C. 206, 207, and 255. If the Department of Labor finds violations against any employers, the DOL can move to enforce 29 U.S.C. 216b to the Department of Justice. After finding the violation against an employer by the Department of Labor shall send memos to each worker involved in order to inform them about the violation and the opportunity to enforce the said violation against the employer. The letter shall instruct the workers to sign the consent and take an oath that shall be authorized by the court to enforce Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216. The Department of Labor has to coordinate to comply with the summons and complaints and cover sheet, JS-44, to file it to the federal court under Section 18 U.S.C. Section 401 or 29 U.S.C. Section 216 to enforce the Social Security benefit under the federal law called FICA. Under the Section 29 U.S.C. 216a, any person who willfully violates any of the provisions of Section 215 of this title shall, upon conviction thereof, be subject to a fine of not more than $10,000, or to the imprisonment for not more than 6 months, or both. No person shall be imprisoned under this subsection except for an offense committed after the conviction of such person for a prior offense under this subsection. Employers who improperly classified nurses as independent contractors, and as a result, employers failed and refused to pay their employer's share of the Federal Insurance Contribution Act, FICA, taxes on each nurse's gross wages, and accordingly plaintiffs were required to pay the same. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses, employers were unjustly enriched. By employers' failure and refusal to pay their employer's share of FICA on behalf of nurses and failure and refusal to pay nurses for travel time between consecutive assignments, they exercised dominion over and appropriated such funds for their own use and benefit, thereby depriving nurses of the rights and benefits thereto. Accordingly, employers are guilty of conversion. As a proximate result of employers' conduct, as alleged herein, nurses suffer damages and are entitled to an award of compensatory and consequential damages. All other similarly situated employees are also entitled to damages in the form of uncompensated overtime wages, liquidated damages, attorney's fees, and other damages so as to preclude employers' unjust enrichment. Pursuant to Section 216b, attached hereto and filed with this complaint as exhibits A through late, the consent to become party nurses executed by each nurse.